Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler here in the studio with attorney Don Ray. Good evening, Don.
Hello, how are you?
Doing great. This evening we are talking about a very, very, very specific area of child support, notices to withhold, which you, sir, are well known to be an expert on. First of all, Don, can you give a little bit of background about yourself and then talk about the topic?
Sure. I'm an attorney in, my office is in Rockford, Illinois. I focus mostly in northern Illinois counties handling family law. And I have had a focus within that on child support issues. And over the years, the notice to withhold income for support for child support or maintenance has really changed significantly. And I've just chosen to follow along with that. And it's been kind of more a hobby of mine to stay on top of the current laws and the trends.
Well, it's a hobby that you're well known for. I'll tell you a story here. So I'm driving to Boone County Court one morning.
Okay.
And I'm always on my phone, which I shouldn't be, whatever. And I check my email, and I see this email from Don Ray about notices to withhold and about child support data sheets. And I immediately think, did I do this right? Did I do this right? Did I do this right?
Well, I got a little bird told me that some attorneys aren't turning in the data sheets.
Sure.
So then their clients aren't getting the money.
That's a big deal.
And then it makes the clients get mad. They call up the clerk's office to find out why aren't they getting their money. And the clerks politely should be saying, that's because your attorney is messed up.
Right.
Follow through. But so they asked me to pass some information along.
And we'll talk about child support.
So it wasn't just you. It wasn't you that was supposed to go to.
Oh, no. I know it went to everyone.
It went to a lot of people.
I went to everyone.
Okay.
It went to everyone. But we'll talk about child support data sheets as well. But let's begin by talking about the form of notices to withhold and why that's important.
There's an actual technical form that somebody's supposed to use to send to an employer to tell them to take money out of the other person's check. 99% of the time it's about child support. So you go to court with or without an attorney, a judge says he's supposed to pay you $10 a week for child support, hypothetically. Somebody needs to fill out at court an order for support. That's something different, which is a 4-page form which has many statutory provisions, requirements that have to be in this form.
And you're referring to a uniform order of support?
No, not so much.
Okay.
There used to be a document called the Uniform Order for Support, which many counties used. It was approved by the Conference of Chief Judges back in, I think, maybe 2001. It was part of a Supreme Court rule that says, hey, every time you do a support amount, use this form. The law changed multiple times. The Supreme Court form never changed. It became very outdated. Last year, I'm going to take it back, I think in 2011, the Supreme Court chose to eliminate the rule. So there is no such animal anymore as a uniform order for support. And why that's important, employers who are really paying attention to the law, when they get these documents, if they have an attorney reviewing them, if you send the wrong documents, the employer is supposed to send them back and say, sorry, wrong thing. And and so if you send a document called the Uniform Order for Support, which no longer exists, they have the right to just kick it back to you because it's not proper to begin with.
And so the form now that is used is what?
There is no standard form.
I see.
I've created one that I use a lot. I think other attorneys have adapted, but maybe not. There's ones you may find in the courthouses, like in Winnebago and in Boone County. They have them on the wall you could use. They actually have the word uniform on them. I strike it out all the time just so there's no confusion with an employer who uses it as an automatic to kick it off. But so the forms, and I think the one in Boone County that was done by Judge Maher is really up to date. I don't know if it's on the wall or not in there, but you could grab one and look and review, or you contact me or another attorney that can review it for you. But,
and these orders are not to be confused with notices to withhold, correct?
Correct. Two separate things.
So what is the notice to withhold?
The notice to withhold is another set of statutory language that tells the employer that they must comply with taking money out of your check or the other person's check. The reason why the order for support is important is that individuals, private attorneys, people who are representing themselves, the federal government requires when you send the withholding notice to the employer to also send the order for support with. It's kind of like a way for the employer to check to make sure they're not getting cheated or some kind of fraud.
And it's the actual order,
It's the actual
as opposed to a notice.
Yes. The state of Illinois, they don't have to send the order. They just get to send their own notice. The state of Illinois used to call their notice order/notice for support.
And when you're referring to the state of Illinois, you mean public aid?
Public aid, formerly public aid, now Illinois Department of Healthcare Family Services, IDHFS. So there was a lot of confusion caused by, in my opinion, the Illinois government to employers of what was really being accepted, what was perfected. Now you're supposed to use such attorneys, when we send these documents, have to send both the notice to withhold and the order for support. The notice to withhold, Illinois has their own set of statutes. That's 750 ILCS 28/20, which lists all the requirements that are supposed to be in this document. Illinois has never had any kind of statutory form to use. Every county's been doing something different for years. That was happening a lot throughout the country. The federal government, 4 years ago, decided to set up this think tank. Anybody could be involved to figure out, well, let's make this brand new form and make sure everybody uses it. Put out tons of press releases, tons of news. Labor organizations are all on top of this. Everybody's waiting for it. There's tons of input. I and many other people volunteered. We made some changes to it. It gets approved. It gets sent to the Federal Office of Management and Budget, and they say, okay, use this form. You can't alter it. You can't change it at all. I and other people, I'm assuming, had said, hey, this form, which is nice, doesn't allow for Illinois' subsection 6 requirement that we have to have on it. So how do we use your federal form? But Illinois says I also have to include the termination date.
That's subsection 6?
I'm just picking one I think.
Sure.
I don't know what it is. It's one of the ones listed.
Okay.
And so there's a contradiction. The feds, through the Office of Child Support Enforcement, they have a very nice website, OCSE, has a lot of information. I was fortunate enough to get a meeting with them. We had a three-way conference with all the head departments, and I asked about all these issues, and then they realized it was a problem. They allowed me, at least for my cases in Illinois, to say, okay, create an attachment page, a 2-page maximum attachment with all the rules that Illinois requires. Because part of the Illinois requirement says you have to list some of the statutes, the details of them. I couldn't list all of them because I was limited to 2 pages. The federal government said, too bad. This is all you get. So I created one, and they approved it. So I had the only form that was approved by the federal government to use in Illinois to send to employers.
And when you say approved by the federal government, who in the federal government?
The Office of Child Support Enforcement. It's the Federal Division of Child Support.
Okay. And they have administrative authority to create these forms?
They created the form. It then gets sent to the Federal Office of Management and Budget. I'm not sure why, but that's just how the forms get approved. And that was approved to be used effective June of 2011. And so after that point in time, they allowed me to do an attachment to it, saying it was going to be okay, and I got approval for them in writing to say to continue to do that.
So now in Illinois, we can use a federal form with an attachment.
Yes.
That includes additional language that are required by Illinois statute.
Exactly.
Why is that important? Who cares?
Because if you send a federal form only, which doesn't have the Illinois additional language in the attachment, an Illinois employer could choose not to honor it because they won't get in trouble. The penalties are part of the attachment. If they're not notified of the penalties, they can't be liable for the penalties pursuant to other Illinois case law.
And we'll talk about what that trouble can mean.
So hypothetically, you send a document to an employer to take the money out of somebody's check, and this is an extreme example. They take the money out of the employee's check. He thinks he's paid his child support. It never gets sent into the state disbursement unit. Mom, on the other side, doesn't know why, doesn't have any idea. She'll call up the employer won't tell her anything, they don't have to tell her anything.
Sure.
She'll call the ex and say, where's my money? The guy's like, hey, it's coming on my check, I don't know what's going on. And he's really innocent, he doesn't know the money's not getting sent in. The employer can get hit for $100 a day penalty per check, every occurrence for that kind of thing. If the form you sent to begin with doesn't go with the order for support, and the form is wrong, because it doesn't list the attachment with the statutory penalties, the employer's off the hook.
So, example, we have an Illinois resident. Both parties reside in Illinois, and they're litigating their case in Cook County. Mm-hmm. But Dad, who is the child support payor, works in Milwaukee for a Wisconsin company.
Okay.
Does the form need to include the federal language as well as the Illinois language, or just the federal language?
You would still need to require the Illinois language because it's an Illinois court-based support order, because Illinois retains jurisdiction. But the employer can only be subjected to the penalties and fines of Wisconsin because the gentleman works in Wisconsin. If it's a Wisconsin corporation, but the guy does all his principal work in Illinois, then the Illinois statutory penalties apply.
Okay, and so, wait, say that again. So, Illinois statutory penalties apply, are you saying in Wisconsin?
No, they would only apply, you still have to notify the employers of all the penalties of Illinois jurisdiction.
Okay.
If the employee, the payor, he's technically called the obligor, the person who sends money is the payor. If the obligor is working principally in Illinois, it doesn't matter where the corporation is. Wisconsin, New York, Hawaii.
Let's say he's working in Milwaukee.
If he's working in Milwaukee,
he commutes.
That company cannot be subjected to the fines that Illinois has. They'd be subjected to the fines Wisconsin has. I just happen to know that the fines are like nothing.
And you would have to enforce that in Wisconsin.
You'd have to probably enforce it in Wisconsin if that company doesn't have an actual corporation registered in Illinois. You could sue in Illinois, but you're going to be stuck using the fines of Wisconsin, which are like nothing.
Sure.
It wouldn't be worth the time to hire the attorney.
So we have a federal form that in Illinois we supplement with Illinois statutory language.
Yes.
In terms of service of these forms, how does that work? Does it have to be, there's any special process?
There's two different statutes in the Withholding Act. One part of the Withholding Act says you can serve that, and it doesn't, just back up a little bit here, part of the statute that says that they must be served. It only provides for service by a licensed agent, let's say through the state of Illinois, a child support worker for Illinois Department of Health Care and Family Services, the individual obligee, the one getting the money, or their agent. The statute technically doesn't allow for the individual worker, the guy who's supposed to pay it, to serve it to his company himself, because it'd be like a self-serving document.
Okay.
So when mom goes to court against dad, mom's got this responsibility to send this form in. Dad can't bring it himself. The employer could reject it because there's no authority to allow them to do that. The method of how the employer can get it, if you're not worried about getting any kind of penalties or any kind of financial recovery if the employer screws up, you could email it, you could fax it, you can hand deliver it, you could do it by Pony Express, so you can just get it to them. There's all kinds of options, but you're not going to be able to get them for any kind of penalties.
Okay.
Up until about 2006, if you wanted to try to make sure to preserve your right to get penalties, you had to send it by certified mail return receipt to the employer. So the employer would get it and then sign for it. You get it back so everybody knows the employer got the documents. A problem happened where the employers weren't withholding, but they just weren't signing the documents. So they were signing the certified mail
receipt.
So there was no way for anybody to enforce that issue to be able to get the penalty because employers just weren't signing for them.
I'm sure that wasn't intentional.
Yeah, right. It's probably a small amount of cases, but those are the same kind of small amount of cases that employers who are going to mess with these people anyway. So it happened a lot. So they changed the law to say, we're going to get these employers, make sure they know how to be served. They get notice by allowing for now certified mail return receipt or by sheriff to have that done. Now the problem that occurs is that if you
So after 2006, you can serve by sheriff.
You can serve by sheriff now.
What about private process service?
Also use a private processor, but not every county allows for that. I think you have to have the restriction of it. At one time, it was like 1 million people in the county to be able to do that. I forget the rule. So you could hypothetically hire a Cook County sheriff to go service on somebody. But a lot of these parents don't have the money to pay $50, $60 to have somebody served.
Right.
I argued against the statute. I wanted the statute to allow it to say you could send it by email, you could do it by fax, but the person who did the serving had to prove in court that the company got it. Put the burden on the person who sent it. The state said, no, we're not going to allow for that. We're going to make it just by certified mail or by sheriff's office. So if you don't send it by certified mail return receipt, and you don't use the sheriff, you can't get the penalties, no matter what the form says.
So you actually made this argument.
Yeah, and I can remember to my face, they said, what's your beef, counsel? Why are you making this so difficult?
Did this go up to the appellate level?
No, it was a hearing in front of the Judiciary Committee on the bill down in Springfield. I was arguing against it because I wanted to allow more access for people to be able to send these things. And they said no.
So the law, as it stands today, is certified mail or
sheriff or private process.
Sheriff or private process.
Right, because I'm not sure what the contingency fees, the contingencies are when you can use a private processor or not. But so typically you could do it by sheriff.
So basically, if you send out the notice to withhold with the order and the two forms, so you've got all the forms correct, you send it out by certified mail, you don't get that green card back, your only option for enforcing the notice to withhold against the employer is to have them served by service of process, personal service.
You essentially hire a sheriff to go do it.
Okay.
And they'll get it done. It's just that you got to dish out the money to do that.
So you have these forms, you've got the service of process, you talked a little bit about some of the remedies, meaning some of the penalties against employers, one of which you said is a $100 a day penalty. What's the law surrounding that?
The law was that if an employer took out money and didn't send it in, they could be subject to a $100 a day penalty.
That's a lot of money.
Okay. Some employer, this is back, let's say 2000. Some employers prior to 2000 just weren't taking the money out. We're not going to get caught up in that analysis. Come after us for some other kind of penalty, but we won't take the money out. We don't need that pressure. So then the state of Illinois, through the Illinois Department of Health Care and Family Services, wised up and said, we're going to change the law to say, if you take the money out and don't send it, or you just don't take the money out at all, it's a $100 a day penalty. So the employers were forced to have to do something. And that came also in conjunction back in 1999 when we were forced to now use the state disbursement unit. It was making sure everybody knew this is what you had to do. The way the penalty works is that the employer gets 14 days after they get this document. They don't have to do a darn thing. But the next pay period, they got to take the money out of the guy's check. If they take the money out of the check, they then have essentially 11 calendar days to make sure it gets to the state disbursement unit. If it gets there on day 12, that's too late. And hypothetically, for that one check, they are then late one day, they owe $100.
Which, at that point, is rather negligible considering what they could be fined. But I'm sure there are cases where there are much more significant amounts. Have you ever run into any of those?
Yeah, I've had cases $50,000, $60,000, $70,000 in fines.
That's a chunk of change.
Yeah, and because many times it's because nobody in the company has the proper payroll process set up to really monitor and make sure it's being taken care of. We've always done it this way. We just send a check in once a month mentality. They don't get to do that. They have to send it in at the same pay frequency that the person's actually paid. So if you get the workers, he gets paid twice a month. The employer has to send it in twice a month.
Now, who has standing to bring that cause of action? Because I'm thinking, and this is what I'm thinking, you've got obviously the custodial parent who is entitled to child support and she or he is not getting child support. But then you've also got this guy or woman who owes child support. Mm-hmm. And like you said, they might be innocent. They might not realize. They might see money being taken out of the check, but it's not being forwarded to the custodial parent, they might be innocent. Who is standing to bring that cause of action for a $100 penalty?
The statute doesn't say who is or who is not. It's my opinion that the person who's supposed to be paying it is not going to be able to file a cause of action because he's not injured in any way. If they don't,
except if his petition for contempt is being brought against him.
then that could be true. Then he just has to show that it's come out of his check and it's been paid. He's off the hook because the court order is for it to be taken from him. Once it's taken from him, he no longer has an obligation to pay it. That's why that order for support form is so important, which says a withholding notice be in place.
It's actually kind of shocking to me that the statute doesn't indicate who is standing to bring that cause of action.
It'd be way too easy. I've argued it for years. Why can't somebody change that language so everybody's very clear who can bring it, who can't, who gets to receive the $100 a day penalty? Maybe in the world of where the money is taken out of his check and he's done what he thought and he's got a contempt action against him. Somebody files in the same case a penalty against the employer. You can see how the mom should have more of a reward for what's happened because she hasn't been getting the money. But the guy's had to come to court, maybe taking a day off work, likely the threat of losing his job because of the employer getting tagged, and he's the guy causing it, and the frustration that the employer has because of him. You would think some of the remedy should be applied to him. It just doesn't say so. And there's been no cases that I'm aware of that says that he can or can't file it.
Have you known of any cases where the visiting parent has brought the cause of action?
The one getting the money taken out of his check?
Correct.
No, I don't know of any cases. I've chosen not to represent anybody who wanted to do that. I just told him I don't think you have the right to file. You can hire me if you want, but I think it's throwing money out the window.
Sure. Have there been any recent changes in the law in regards to penalties?
In regards to penalties, last year, around let's say February of 2012, one of our state representatives out of DeKalb, I don't know who he knew, but he was upset that one of his constituent employers got tagged for a big fine in DeKalb County for what he called an honest mistake. He proposed some legislation. Within 3 months, it went through and got passed. That legislation then said that you have to change the actual structure of the withholding notice as far as the size of the font, that it has to be bold, and you have to list all of the statutory duties.
So the form has changed again.
The form has changed again, and the complexity of it is so much that now that form that I got approved for the 2-page attachment,
right,
I no longer use just a 2-page attachment. Mine is now 8 pages total.
How's that approved by the federal government?
It hasn't been approved. They won't contact me anymore. And part of the reason I think won't contact, because many states have also had to add something way bigger than 2-page attachments.
Sure.
Like Florida created a whole new law. They call it an addendum, so it's not really part of the withholding notice. It's just an addendum to that gets sent out. It's like 6 pages too. It's crazy. But this law then created that to make sure that the employer was properly notified. It makes sense to me. I understand. I get it. But if these employers, they have an attorney, or the employers could just read the law themselves. You should just be able to cite, please read statute so and so.
Well, I get it. It seems with larger employers, Chrysler out here in Belvedere,
right?
They would know the law. Smaller employers, mom and pop kinds of places, I mean, they should, I guess. They're required, like we're all required to know the law, but that would be much more difficult for them.
You would think it would be much more difficult for them, but Chrysler, I've had suits against Chrysler. They don't care either. It just nobody seems to care.
Sure.
So now the employer is supposed to be given this big document telling them all the statutes, which essentially kind of dwarfs the important ones, but we're required to give it to them. They are also required, the people who send the withholding notice, the mom, for her to be able to try to collect the penalty and preserve her right, as soon as she finds out that a payment's missing, she has to send to the employer by certified mail, it's part of the statute, saying, hey, I didn't get my payment. Please somebody tell me what's going on. Now the mom who doesn't get the payment, she doesn't have access to the payroll records. She doesn't know for sure when the money gets to the SDU. She has no way of knowing whether the screw-up was she didn't get the money because the number of days has elapsed properly or it's improper. She has no way of doing it. So let's say it happens 2, 3, 4 weeks in a row. She has to send out certified letter, certified letter, certified letter.
She has to send out a certified letter every single time she doesn't
every single time she thinks there's offense. If she doesn't, it's part of the new statute. She's not going to be able to collect anything.
So that's a $5 letter for every possibly $60 she doesn't receive.
Exactly.
Really?
Yeah.
What it comes down to.
Yeah. Essentially, unless you have, in my opinion, an attorney to do this thing properly, the whole thing, and there's a lot of attorneys who don't know how to even just do the form, nobody's ever going to be able to recover any kind of penalties anymore.
And even if the forms are done correctly, there's
so many
custodial
steps.
parent needs to follow up with sending a certified letter every single time she doesn't receive payment, correct?
Correct, yeah.
How about the amount of penalties? Has that changed at all?
The amount of penalties has not changed. There's a different penalty that's not just the $100 a day one, which does not require certified mail to be served or the sheriff. It's if the employer the employer takes the money out and they don't send it on time, you still can get that amount as a judgment against them for not turning in the money. So they still can recover the amount that should have been taken out or the amount that they did and held on to, but you can't get the $100 a day penalty, just those amounts. So let's say the employer takes the money out, puts in a bank account, they do for 10 employees, each from paying $100. They have all this money sitting in their own account they can use at their own disposal until somebody calls them on it. And what's the worst that's going to happen? Turn over the money. So it's not really a penalty. There's no risk of the employer to hold on the money. So mom can get that, but it's doing nothing for her.
No more $100 a day penalty.
Mom can get the Mom can only get the $100 a day penalty if you do it by certified mail. You still could recover the money owed to you, but you don't have to do it by certified mail. But at what cost to the parent? She's got to hire an attorney to do all kinds of stuff.
Absolutely.
And there's no provision in the statute to allow for recovery attorney's fees. So it just becomes an endless session with mom trying to find out why I'm not getting my money. Nobody will tell them.
That is a huge change in the law. Are these cases even worth litigating then?
That becomes only if you get the $100 a day penalty thing.
Okay. Yeah.
Yeah.
Is there a cap on that now?
There's a cap on that now also with that new statute. It says $10,000. I called up the representative in DeKalb and asked him about that, and he told me it was per offense. And I said, does that mean that each time they don't take the money out, like on each week? He said, yes, that's what that would mean. So the only authority I would have to file a good faith complaint based upon it's $10,000 per check versus $10,000 total is what this state rep told me as a representative of what, because he's the one who proposed the statute, that's what it means. So if there's 7 checks, arguably $70,000 is the cap, not $10,000.
I see. Okay. But you have to go through all of those procedures. We're not just talking about the form now and proper service. We're talking about the person who's supposed to be receiving the money needs to send a certified letter.
Yeah.
As well as all those other things.
Correct.
Okay. Well, then there is some incentive there if someone has properly followed the procedure. Yes?
We mean incentive for what?
Incentive for litigating that and filing a lawsuit.
Well, yeah, but it's a huge expense for them because not many attorneys are going to do it on a contingency fee. And how much money do you got to dish out to try to recover potentially, $10,000 in fines?
So, are there difficulties in what are the difficulties in succeeding in these kinds of cases? Obviously, you mentioned some of these requirements, but are there any specific ones that stand out in your mind?
Well, I had one case that I ended up withdrawing from that it became difficult because the prior attorney who did the forms I didn't feel were adequate enough after the law changed. There's been a case that came out this year that had a woman's withholding notice penalty case against an employer who clearly screwed up, had it all dismissed because she didn't put the Social Security number on the form. Some attorneys will send out the withholding notices without the Social Security number, without the proper things on the form, so then it becomes difficult to weed your way through to find out whether the other attorney catches things or not. But the angle that seems to be the new defense when somebody is messed up is to say that they didn't have specific knowledge or an intent to withhold the money, because the statute's a little ambiguous as to what the employer is supposed to have done or not done. I haven't seen any cases that talk about the employer's intent or not. It's my opinion. It's not whether they knew they were doing it wrong intentionally or not. It's whether they chose to take the money and not send it. If they just didn't do that, there should be like a presumption, but there isn't. There's only a presumption that they did it wrong if it's happened on more than one occasion. And it gets very confusing the way the statute's written down. It could be done a lot better. I mean, in my opinion, the statute should be completely overhauled because there's so many problems with it.
You talked about the intent of the employer, so that has no bearing. Are you saying that has no bearing on whether or not they should be fined or sanctioned?
I'm saying that my opinion of the statute does not allow for what their intent was. If they took the money out of a guy's check and they used like a third-party payroll company to do the processing, and mom is still out with 4 months of checks, that shouldn't matter. Their penalty is a strict penalty for their liability for doing something wrong. It's not because that they intended to do it wrong. It never says that they have to intentionally doing it.
Is there a negligence standard then?
It just says they knowingly failed to withhold or knowingly took the money out and didn't send it.
Okay.
Now, if you didn't take the money out, it becomes impossible for mom to prove that they knowingly didn't take the money out because they didn't take the money out.
Well, that seemed to me like a pretty high standard.
It seems.
For instance, you could send an employer, do it by process, correct service, send it, correct forms, all that kind of stuff, and then the employer can make an argument that it's not that I did this knowingly, I did it negligently. The form got stuck in a pile of forms and boxes in the back office, and we got it, but it wasn't it's not that we failed to do this knowingly, we just forgot about it.
Right, and I bet that happens. But because of these requirements, all this information is required to be sent to them. Hey, dummy, don't screw this up. The screw-up accident thing really shouldn't work. You have to they're given 8 pages of information. Read this, send this in. It's on every website with any kind of labor law type organization. They know about it. These employers are told. Federal government sent them to all businesses registered throughout the country in 2011. Here's the new form to use. You must comply. For somebody to say, well, I didn't by accident because I got set on Susie's desk, that's too bad, in my opinion. There needs to be a process to make sure that when they get these things, it's done correctly. I bet these people don't have a problem with making sure the federal taxes get withheld and sent on time.
Very true.
Or their union dues are taken out of their check. There's got to be a process set up to do that. And so the accidents, they do happen, but they shouldn't happen because they're told to make sure that they don't happen.
Looking at the law now, are there any changes that you think should be made when it comes to notices to withhold to help people? Or, too strict for employers, for that matter?
I think, and this is based upon me doing this for years and talking with employers, they would very much appreciate if we could send it by email to them. So we could send it to the specific person that they wanted to go to within that corporation to help the process along.
Yeah.
Sending it by certified mail to the person at the front desk. It may not get to the human resources person in payroll for 3 or 4 days. Then they may not get to it, and so the time frame lapses. The next thing you know, they're faced with that penalty if they don't take the money out the next day. Allowing us to send it by email and still be able to get the penalty, I think, would be an important change. There definitely needs to be a format that everybody can follow that includes the Illinois requirements of what the actual withholding notice should be. The Illinois Department of Health Care and Family Services needs to step up to the plate and do something about it. I just sent another email out yesterday to them, the federal government, saying, make this happen, please. Make it easy for everybody. They refuse to. Illinois is one of the few states that the form they choose to use, they won't even publish online for you so you could take it offline, just copy it. They don't make it available for the public. It's amazing to me.
Why do you think that is? That doesn't make sense.
I have no idea. For a while, they were saying that their form was in compliance. I don't know about anybody else, but I'm assuming other people besides me were complaining that their form was wrong. It didn't meet the new federal form. Illinois, for whatever reason, has got this company called Maximus out of Chicago that they've hired as a third-party contractor to do a lot of their withholding notice work. Instead of just copying and pasting or downloading the PDF form that's on the federal site and then using that, they have a prior form with a different kind of font set up Maybe it's computer generated and based. So they've chosen, coincidentally, I think out of convenience and probably money, not to change the form to make it look exact. And so there's flaws with it. I kept telling them, this is wrong. This is wrong. They finally made new changes. A lot of the changes aren't perfect.
You mean things that are not following the statute?
They're following the statute or following the federal form.
Okay.
Illinois still is not sending out a withholding notice to an employer that has somebody's social security number on it, even though that case came out in January saying you have to or they get tossed. The federal law requires it on the form. Illinois just sends it blank. They don't fill it in. So there needs to be some meeting of the minds. I don't care who it is, just get it done. It's just not happening for whatever reason. Another thing, the law, I don't believe we have to include 8 pages of all the actual statutory text. We should be able to say, please read this statute. It affects your rights and responsibilities. We can condense the paper so we don't have to send these things to the employers.
And people can Google the statute.
Yeah.
Put that in there. People can Google the statute.
And if we send it by email,
seconds.
we can have the link on it. You just click the link and it opens it up.
Right.
It's in my form doesn't have given a lot of attorneys. It's designed to do that. Make it so easy for everybody. It would eliminate a lot of problems. I don't like the fact that the law changed in 2000. I believe it was 2011. That said that if you file a withholding notice, you don't have to file it with the clerk's office anymore. You should only be filing it if there's any kind of lawsuit pending, which then state of Illinois, when they would send out withholding notices, whether they're wrong or not or right, they no longer have to file them with the clerk's office, which means they don't have to send them to the attorneys of record. So we don't know when they make mistakes. They make mistakes a lot. Not intentionally. It's a computer-based driven system. They make mistakes. They may have an outdated order. There may be a delinquency they think exists. We used to catch wind of it because they would send them to us because part of the clerk record requirement is that if you file something, the attorneys would be given copies of it. So they just changed the law so they didn't have to file it. So we don't get it. And I think a lot of that too.
This is only for public aid?
Well, nobody has to file it.
Nobody
has to. I file mine all the time anyways. I'd rather have somebody yell at me that I filed it.
Yeah, so do I. I file mine all the time.
But you don't have to file them anymore. Essentially, the statute it applies. Don't file it unless there's a case pending or there's a conflict.
I file it because I want some kind of proof that it was sent out.
Exactly.
Here on this day, I filed my notice to withhold with the clerk of the court, and I have a proof of service.
Sure.
Send it out by certified mail, and then
and I do the same thing. After I file it, then I'll email it to the employer saying, here's what got filed with the clerk's office, just so you know. And the employer's like, thank you very much. That way we know it's been all taken care of. And 90% of employers are like, great, let's do this.
Sure.
But so that law should get changed.
Lay people listening, the common mom or dad out there that is having to deal with this. What are things you think they should know? I know we've talked about a lot of technicalities, which are very, very practical for them. But a lot of times lawyers are dealing with these things. But what are key things that you think people should know who are either paying child support or who are receiving child support in relationship to notices to withhold?
Because it's so essential the employer gets this information that when you're in court, and if the other person is there with you, you try to have them make sure to put down in writing, possibly even in the court order, or what's called a child support data sheet, the name of the employer, the address of the employer, and the telephone number. And then you can do some research, most of the time online, to find out where this address of the company is to verify it and call them up. And if you can just, they don't tell you a lot of information, but the more polite you are to them, say, I need to serve this withholding notice, could you please send me to payroll or accounting? And a lot of times the employers have no problem doing it.
Sure.
What can be helpful to lay people is that if they're not getting cooperation and they believe it's an actual corporation they're sending it to, you can go online to it's called CyberDrive Illinois, and you can look up any corporation there is in Illinois, and on that they'll have the registered agent and the address, so then you can send it to that place by certified mail. That's a real key thing, that they're not going to find the information in any kind of courthouse.
Do you have to send it to the registered agent?
No, you don't, but for sure they have to sign for it. So you get that certified process taken care of.
So the child support data sheet, sending things to going on CyberDrive.
And that's for corporations only. That's
for corporations.
Yeah.
And any other practical knowledge that lay people should know about these notices to withhold?
That you can always go to the federal website to get the most update version or any changes. There's a lot of positive information on there, such as where you can serve them for federal government agencies. Rely on the federal child support website. Don't rely on the state of Illinois' website. It's woefully inadequate. The clerks at the courthouse, they don't have the knowledge. They don't know. They would probably love to help you, but they don't have the information. Don't get frustrated when they're not telling you. It's not intentional. They have no axe to grind with you. They just don't know the correct information. So you may have to go talk to an attorney. Ask for a free consultation with somebody. People will be, I would think a lot of attorneys will be willing to help you out. But don't give up. Don't feel it's against you. Nobody has an axe to grind. Just look for the information.
Well, Don, I thank you for talking to us this evening, talking to me this evening.
You're welcome.
You know the stuff we all know in and out. And people ask you for forms. People ask you for advice. And by that I mean other attorneys in regard to this information, because it's complex, and we all don't want to mess it up because there's significant consequences. And in addition, we simply want to make sure that our clients, as attorneys, as divorce attorneys, get their money. Your office, where is it located?
Rockford, Illinois, off of Bell School Road. You could find me. You could type in child support or divorce in Rockford and my name, Don Ray, on the internet, and you'll be able to find me.
And if they want to contact your office by phone, what's your number?
815-713-1272.
Well, thanks again, Don. I appreciate talking to you.
Thank you. Appreciate it.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com, Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tangler, please visit TanglerLaw.com.